We hope that your lordship today finds that the disputed trade was legitimate and should not have been void. We appeal the decision taken in the Court of First Instance on two grounds. The first being that the Court of First Instance erred in concluding that because Clevity operated a distributed ledger with a node in the DIFC, that the DIFC had jurisdiction over the claim by Mizrani against Mr. Payne under Article 5A, 1B of the Judicial Authority Law. The second ground of appeal is that the Court of First Instance erred in concluding that Article 36, 1A of the DIFC contract law was sufficiently satisfied by Ms. Rani, showing that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was a result of an error. I will be challenging the court's jurisdiction, while my learned junior, James, tackles the issue surrounding relevant mistake. To challenge the court's jurisdiction, to challenge the Court of First Instance's jurisdiction, I will be reviewing the facts of the case and questioning the applicability of the authorities by applying the facts and the relevant legal material. So the judge in the Court of First Instance erred in concluding that because Clevity operated a distributed ledger with a node in the DIFC, that the DIFC court had jurisdiction over the claim. The judgment relied on the decision made in the 2011 case of Al-Khurafi and Bank Sarsin, and particularly paragraph 60 to 65. The paragraphs can be found on page 10 of the appellant's bundle. So in this case, it was held at paragraph 61 that each of the component contracts was a part of the overall investment transaction, and that each such component was at least partially, if not wholly, concluded in the DIFC. However, let us consider the facts of the case before us today. We have a valid contract with offer, acceptance, and consideration in the form of a transaction. Nevertheless, there is uncertainty around where this transaction took place. This is quite unlike the facts found in the case of Al-Khurafi and Bank Sarsin. The transaction in the case before us was done on the cryptocurrency trading platform Clevity. Clevity is hosted on a distributed ledger across hundreds of digital nodes in many countries and locations, including the DIFC. As for in the cited case of Al-Khurafi versus Bank Sarsin, there was confirmation of the transaction taking place or interacting with the DIFC. Now, due to the nature of this decentralized system of Clevity, we are unable to track which nodes exactly interacted with the transaction in question. There is no evidence that points to the interaction of the transaction with the node that's present in the DIFC. With no evidence, we cannot know for certain or assume that the interaction took place. And if we have no evidence that the DIFC is involved, the court cannot have jurisdiction. Now that we have examined the facts that are before us, in the case before us, let us apply them to the law. If I could please invite your lordship to turn to page 12 of the appellant's bundle, where you will find law number 12 of 2004 in respect of the judicial authority at Dubai International Financial Center.
Yeah.
In front of you, you have Article 5A1B, which grants the Court of First Instance exclusive jurisdiction to hear and determine matters relating to civil or commercial claims and actions arising out of or relating to a contract or promise contract, whether partially or wholly concluded, finalized, or performed within DIFC, or will be performed or is supposed to be performed within DIFC, pursuant to express or implied terms stipulated in the contract. So while our transaction fulfills the elements of a commercial contract, it does not in any degree relate to the DIFC in terms of the parties involved. And there is also no evidence of it being partially or wholly concluded, finalized, or performed within the DIFC, or evidence that it will be performed or is supposed to be performed within the DIFC. Again, while this section was applicable in the case between Al-Khurafi and Bank Sarsin, the context of our case is significantly different, making this judgment an inappropriate one to rely upon. The fine but crucial details of the context are sufficiently different in the two cases, to the point where the case before you cannot, under any circumstances, rely on the judgment in Al-Khurafi and Bank Sarasin and its applicability to the law, purely due to the point of the interaction with the DIFC, or lack thereof. In Al-Khurafi, that satisfied the element of Article 5, while this is not applicable in the case before the court today. In light of the uncertainty around where the transaction took place, we cannot simply assume that it was partially or wholly performed in the DIFC. Without the certainty of the crucial facts, we cannot grant the DIFC court of first instance exclusive jurisdiction on the matter, where the law doesn't even grant them one. Nevertheless, Section B1A of the same law grants you, my lords, exclusive jurisdiction to overrule a decision that should not have been taken in the first place. On the basis of the foregoing, we ask your lordship to hold that the court of the first instance erred in concluding that because Clevity operated a distributed ledger with a node in the DIFC, that the DIFC had jurisdiction over the claim by Ms. Rani against Mr. Payne under Article 5A1B of the Judicial Authority Law. If I am no further assistance, these are my submissions. Thank you.
Okay, well done. My suggestion is that we don't do questions just yet, that we move to hear Payal in response. So Payal and Shakira, how would you like to divide your 45 minutes?
We'll divide it by 15 minutes each.
Great, fine. Then please go ahead.
Okay. May it please the court, my name is Paljing and I appear as a senior respondent on behalf of the respondent Razrani in these hearings with my learned junior, Ms. Shakira Zainab. If it pleases your honor, may I proceed to state the facts?
Please proceed.
The appellant and respondent are both users of the Clevity platform, a digital platform to trade in cryptocurrency. Owing to a system glitch brought on by a routine upgrade, the appellant and respondent were the only users who could trade in the cryptocurrency Yapple. A disputed deal was completed between the parties at a price 250 times higher than the current market rate, for which the respondent brought proceedings against the appellant on the grounds that the trade is void for unilateral mistake. The court of first instance ruled in favor of the respondent, but the decision was then appealed by the appellant. In response to the submissions made to your honor by the appellant, I shall be addressing the first point of appeal through an essential submission opposing the appellant's views. I would like to direct your honor to page 5, paragraph 8 of the code bundle, namely that the DIFC has jurisdiction under Article 5A1B of the Judicial Authority Law, thus the appellant's continued performance is not justified. In this case, your honor, I would like to make a submission in response to the first ground of appeal as previously stated. And this will place a greater emphasis on the factors asserting that as accurately determined by the court of first instance, the DIFC court had jurisdiction over the claim and was obligated to consider the claim and authorize an evaluation that the trade is void for unilateral mistake. If it may please the court, I would like to proceed with my submission. Your honor, I would like to proceed by stating that the court of first instance has exclusive jurisdiction as in Article 5A1B of the Judicial Authority Law, which indicates that claims arising in relation to a contract, whether partly or wholly concluded, finalized, or performed within the DIFC comes under the jurisdiction of DIFC. Additionally, the leg size of the crypto asset is also considered when determining the jurisdiction of the claim. Thus, the appropriate jurisdiction for a valid claim is the place where the individual or the company who owns the asset is domiciled, or when the damages have occurred as a result of the acts which are committed within the jurisdiction. As your honor noted in the case of Iron Sciences and Persons Unknown and others, reported on 21 December 2020 Commercial Code, which can be found at page 21 of the Respondent's Code bundle. To support this argument, I would like to present the case of Iron Sciences and Persons Unknown and others, reported on 21 December 2020 Commercial Code. Would your honor prefer a brief summary of the following case?
Proceed.
Yeah.
Iron Sciences and its sole director, Duncan Jones were victims of an alleged initial coin offering fraud. They claimed to have transferred Bitcoin after being convinced by unidentified parties that they were buying authentic cryptocurrency goods, only to learn that the recipient was a fraud. To protect the transferred Bitcoin, Iron Sciences and Mr. Johns applied for a proprietary injunction, a global freezing order against unidentified parties, and a disclosure order which was directed at cryptocurrencies exchanges in the form of a banker's trust order. The case's primary question here was whether the court had jurisdiction in the application for interim relief and if the governing law of the claim was English law. The court referred to the analysis of Professor Andrew Dixon in page 23, paragraph 13, in determining the lex situs of cryptocurrency is the law applicable where the person or the company who rightfully owns the cryptocurrency is domiciled or has its registered office. In this case, it was found to be English law. The court concluded that the applicants had shown there was a serious issue to be tried on the merits of their claims being bought or intimated in deceit, unlawful means conspiracy, and by the way of an equitable proprietary claim, as highlighted on page 22, paragraph 13 in the respondent's code bundle. Furthermore, the proper jurisdiction for the trial of the claim was found to be England. The claim may have arisen from events that occurred within the jurisdiction, the damage occurred within the jurisdiction, the applicants were domiciled in England, and the relevant funds and Bitcoin were based in England, allowing the applicants to satisfy the requirements for serving outside the jurisdiction as highlighted on page 24, paragraph 116 in Respondent's Code Bundle. This is in accordance with a legal interpretation of Article 5 of the Judicial Authority Law, which states that the basic requirement to have jurisdiction is to have a contract to be concluded or the acts taken under the contract to be performed wholly or in part within the DFC. The criteria is satisfied because Clevity functioned using a distributed ledger and can be inferred from the contract between the users that the part of the business was run from DFC as one of the servers is located there. The lex situs of YAPL would thus be in DFC as it is the place where Clevity is domiciled partly. Your Honor, I would further like to emphasize the first ground of appeal made by the appellants regarding DFC having a jurisdiction over the claim, and the Court of Appeal should validate the decision reached by the Court of First Instance. According to the lex situs of the crypto assets, YAPL would be in DFC as one of the nodes of the platform is based in DFC, such that the damages have also occurred as a result of the acts which were committed within the jurisdiction as well, and hence the decision of the Court of First Instance should be upheld. Your Honor, to highlight my viewpoint, I would like to present the case of Fetch AR Limited and another, and persons unknown and others reported in 2021 Commercial Court of England and Wales High Court at page 2254 that can be found at page 25 of the Respondent's Code Bundle. Would Your Honor prefer a brief summary of the following case?
Please proceed.
An English firm, Fetch AR Limited, and a Singaporean company, Fetch AR Foundation Pte Limited, filed this lawsuit, alleging that the fraudsters had access to the first claimant's Binance accounts, which included a variety of cryptocurrencies. The perpetrators then traded these cryptocurrencies for amounts that were far below the market value in order to move them implicitly to their own wallets. This value drop was estimated to be about $2.6 million. Claims for confidentiality breaches, unjust enrichment, and an equitable proprietary claim based on the unlawfully acquired property being held on a constructive trust were brought in by the claimant. The critical question in the case was whether England and Wales had jurisdiction to hear the claim when the cryptocurrencies did not belong to a specific place and the claim was brought against unknown defendants. The court applying the Iron Science case were persuaded that there was a serious issue to be tried regarding whether the cryptocurrency is a property or chosen action for the purposes of English law. The lex situs, which is the law of the place where an asset is situated of a crypto asset, is the location where the person or the company who owns it is domiciled. The primary applicant and the owner of the accounts were resident of England, and the law of the place where the object of transaction is closely connected to applies. Therefore, the English courts had jurisdiction as highlighted at page 27, paragraph 13 of the Code Bundle. Your Honor, in the cases mentioned above, it is evident that the damage has occurred as a result of the acts which are committed within the jurisdiction, and the relevant asset YAPL may be based in DFC. Thus, the object of the transaction YAPL is closely connected to DFC, with which the respondent satisfies the standards of serving outside the jurisdiction. With this, Your Honor, my submission is concluded. If Your Honor has no further questions, shall I proceed with my conclusion?
No, let me intervene. I've got questions for both of you at this stage. So let me start with Yara, sorry, please. Looking at your instructions, it's that one of Clevity's node is on a server based within the DIFC, and we're told that the whole of Clevity uses a distributed ledger to allow for simultaneous access, validation and record updating in an immutable, so an unchanging manner across the network. Now, you've made the point that we've got no specific evidence that the disputed transaction or trade took place on the node within the DIFC. Nonetheless, it seems to me that the description of the system, Clevity's entire system, means that it's a fair assumption that some of the processing took place within the DIFC, and that is enough for me to find that the contract was partly performed within the jurisdiction. What do you say to that?
So, my lord, the thing about this decentralized system is that, yes, there are nodes everywhere, and one of which is in the DIFC, or some of which is in the DIFC. However, we do not know that our particular transaction interacted with that node. And based on that, we cannot assume, or we cannot make an assumption for that it did in fact interact. So due to this uncertainty, we cannot know for certain that it did interact with this specific node that's within the DIFC, which would give the court jurisdiction.
Okay, no, I agree that we don't know. I mean, another support for my presumption argument would be that the nodes are distributed around the world to give global coverage, and generally servers when you do a transaction on the internet, it's the server closest to you which processes the interaction. And given that one party is in the Emirates of Dubai and the other is in the Sultanate of Oman, it's likely that the nearest node was the one within the DIFC, isn't it?
Not necessarily, because, so you said it is true that one of our parties is in Dubai, but outside the DIFC zone, which is crucial, and the other party is in Oman. So the facts of the case did not tell us where the other nodes are. It just told us there is one in the DIFC and several other around the world. So there could be an even closer node to the party in Oman, but could is not strong enough to have an assumption based on that and have a concrete evidence. There is no evidence. It could have interacted with a node in Oman that was way closer to where the transaction took place. So just because, you know, it's not necessarily. Sorry, go on.
No, that's good. Before I hand over to Nasser, if he's got any questions, Payal, I've got a question for you. There's a doctrine in English law. You see, the Article 5 language is mandatory. Once you find that one of the 5A1 qualifications about an establishment, a contract, an incident, a law, whatever it might be, is found, then the DIFC court shall have jurisdiction. It's mandatory language. But actually, it is possible for the DIFC courts to decline jurisdiction nonetheless. And one ground for it doing so is called, the Latin tag is called forum non conveniens. It's the idea that the DIFC is not the most appropriate or natural tribunal for this appeal to be heard. So, Payal, are you there?
Yes, Your Honor.
Yeah, you're there. Okay, so if we look at the raw ingredients of the claim, we've got one party based in the Emirate of Dubai. We've got another party based in Oman. I'm just guessing from their names that they're not necessarily, so neither party is based in the DIFC. and guessing from their names that they may not necessarily want to carry out their litigation in English. They might be happier litigating in one of the civil law courts of Dubai or Amman. Their programs are not connected to the DIFC in any way. It's likely that the money that underpins the trade in YAPL is held in bank accounts outside the DIFC. So in other words, it seems that on the facts of the potential dispute, the DIFC is not the most appropriate court and it should decline jurisdiction. What would you say to that?
Your Honor, for the jurisdiction to apply, regardless of the respondent's location and the claimant's location as well, she can still apply. The respondent can still apply for jurisdiction because they are satisfying Article 5A1B and Article 5A1C as well of the judicial authority law. They have a contract there's a contract between the parties and between the users as well for standard terms and conditions for trading. So, and because one of the nodes is served in the IFC, we can affirm that that a part of the activity is performed within the DIFC. So it is fulfilling the jurisdiction requirement as per the judicial authority law, and therefore the parties can apply for the jurisdiction here.
Okay, so you would say, notwithstanding the facts that take this outside the DIFC, you say there are facts like the existence of the node within the DIFC anchors it to the DIFC, and then you again stress the exclusive nature of Article 5 and the test therein. Okay, and Nasser, do you have any questions?
I think,
Yes,
Peter,
Your
you.
Honor.
I heard Nasser. Did you say Nasser or someone else?
Yeah, Nasser, yeah.
Yes, okay. Peter, I think you've asked the two most important, especially when you use the follow-up questions, you really clarified the most two important questions I had for both Yara as well as Payam. But I just want to make sure, just to understand how you see it, Yara. So if you have a blockchain, your understanding of that technology, I'm sure as a lawyer and to be able to defend this case, you don't have to be an engineer or a software programmer, but you should understand, of course, the main components of how blockchain works. So your understanding of blockchain and a distributed ledger, can it work without the interference of one of the nodes that are part of this blockchain, or it has to have the interaction of all the nodes to make such transactions? So your understanding of a distribution ledger as well as a blockchain technology, can it work with few of the nodes, or it should involve all the nodes to be able to see that this is a complete transactions and completely stored within the distributed ledger?
So to answer your question, our understanding of blockchain, or the cryptocurrency system, is that it's essentially this huge cloud with servers everywhere. But just because it has servers everywhere, which are the nodes, doesn't mean that each one of the servers is involved in each transaction.
That's my question to you. Understanding of blockchain.
Sorry?
So that's my question to you. Do you have a solid, argument that it does not involve all the nodes when such a transaction happens?
Yes.
Okay. The second part I had is that you had an argument about, the location, I think, of the people making the transactions, as you were referring to it in one of the DIFC. So in addition to questioning the node being part or not, you're also questioning the people location. Am I correct?
So we do know that there is one node or there is a node in the DIFC. We don't know 1, 2, 3, whatever, but we do know that there is at least one in the DIFC. But we do also know that there are many outside of the DIFC, and we do know that the parties are residents in the Oman and Dubai, but outside the DIFC zone. So just because, so we don't know as I said, we don't know the locations of the other nodes. So there could have been ones that are closer to them, which maybe interacted with the transaction. That's what we're saying. I hope that answers your question.
Okay. Fair enough. I think that the rest of the questions was already asked by Peter, so I'm not going to repeat it. I'm going to go to Paya then. It's also follow up to Peter's questions, but just to make sure I understand it clearly from you, Paya. Am I pronouncing your name correct?
Yes, Your Honor.
Yeah?
Yes.
Fine, excellent. You referred into one of your arguments related to domestic law or applying domestic law because of the property, basically the owner of the Bitcoin as you've explained becomes then a property, and then the owner of that property, we apply the domestic law according to that. Did I understand you correctly when you mentioned that?
Yes.
Okay, so maybe follow up to Peter's question is, again, let's say we have two owners here at least. The original owner, and then of course the new one. One is located in Dubai, not within the jurisdiction of the DIFC, and the other one is located in Oman, again, of course, outside the jurisdiction of the DIFC. So how do you see that DIFC law in such case will be applicable? Now we're not talking about the node. Now we're talking about the owner of the cryptocurrency. How do you understand the DFC law in that case should apply? I want to make sure I understood your argument when you use that.
Yeah, as I was saying, the Article 5 of the Judicial Authority Law gives exclusive jurisdiction to the residents, to the people, so that when it gives exclusive jurisdiction to the parties involving claims that are arising in relation to any contract, whether it was partly or wholly concluded in DFC. And in this case, we are establishing that the contract was partly concluded in DFC. The activity, the entire claim was partly performed in the DIFC as one of the nodes. So node is based in DIFC. And also according to Article 5A1C as well, the incident or the transaction was partly performed within the DIFC and is also related to the activities of the DIFC. Cryptocurrency trading comes under the activities of DIFC. So we have been claiming that they have exclusive jurisdiction to hear the claim. And the parties can apply to the jurisdiction as it is also in favor of the respondent.
Okay, I'm just trying to understand when you made the argument about, applying the English law and Wales law because the Bitcoins were located in UK and Wales. So I'm just trying to relate that to our case to make sure I understand you better. I think I'm referring here to pages 24, 25, when you were making your argument, Paya, in your intervention.
Just a minute, Your Honor.
Yeah.
Yes, Your Honor. Although we do not know the exact location of the cryptocurrency YAPL in the present case, I'm establishing that Clevity as an organization was partly domiciled in the jurisdiction in DIFC, and though it is not a party, but it is a platform where the users had an account and they had a contract with the parties for standard terms and conditions for trading. So this Clevity functioned using the distributed ledger and from the contract between the users, it can be established that the business itself was run partly from DIFC and the server is located there as well. So that's why on the basis of these arguments, Lex Citus of YAPL would be in DIFC.
Okay. Thank you, Kaya. I think I understand your argument, but I'm just not sure that that it's quite clear. Anyway, thank you very much.
Thanks so much, everybody. Shall we then move on to James?
Good morning. Good morning. Before I begin, may I ask how the bench would like to be referred to? Your Honor, my Lord, what's the preference?
Your Honor.
Okay, Your Honor. Good morning, Your Honor. Would we still be doing rebuttals or replies?
Yes, yeah.
Okay, so would Yara be able to return to do her reply at the end of my submissions, or should she go now?
Oh, I see. We've sort of broken that down, I think, more into questions. Yes, okay, that's a good point. Yara, would you like to go now then? Yara and Pale, just have 5 minutes, whatever you need to do some rebuttal.
Yes, please.
Yeah.
Sorry, my computer is down, so I will be replying from James's.
Yeah.
No, it's fine. It's fine. It's fine. So we would like to remind the court that we appeal and on the Court of First Instance's jurisdiction, based on that the Court of First Instance erred in concluding that because Clevity operated a distributed ledger with a node in the DIFC, that the DIFC court had jurisdiction over the claim by Ms. Rani against Mr. Payne under Article 5A1B of the Judicial Authority Law. We would also like to respond to some of the points that were made by our respondent team. So to begin, to start off, the first case that was referenced by the respondent team was said that the court had jurisdiction because the system was registered in the UK. However, we do not know where Clevity is registered. Therefore, this case is irrelevant and unapplicable. The second case that was referenced by the respondent team was said that the court had jurisdiction because the residents were in the area or in the country, where, again, this is not applicable because one of the parties is a resident of Amman and the other one is in Dubai, but outside the DIFC zone. We would also like to say that based on those points and based on the principle of forum non-convenience, which was mentioned by Your Honor, it would not be convenient. We do not see the convenience of the court being the court of the DIFC hearing this case and having jurisdiction over it, because the DIFC, or at least we don't have proof that it's interacted with the DIFC, and none of the residents are in the DIFC, and the program we don't know if it is registered in the DIFC. So based on those 3 points and the Article 5A1B and the principle of forum non-convenience, we urge the court to hold that the Court of First Instance erred in concluding that because Clevity operated a distributed ledger with a node in the DIFC, that the DIFC had jurisdiction. Thank you.
Thank you, Yara. And Payal, any rebuttal?
Yes. Firstly, I would like to make 2 points as well, 2 submissions opposing the appellant's views for the rebuttal. Firstly, Clevity may not be registered. It hasn't been given any facts if it is registered in the IFC, but it wasn't just about the about the company being registered or domiciled in the country in the jurisdiction for the jurisdiction to apply. It was also about the damages that have occurred because of the acts which were in the jurisdiction, and also about the relevant funds and the cryptocurrency which was based in the jurisdictions. Here, in this case, the acts which were undertaken under the contract were performed in part within the DIFC, and that's why the criteria is satisfied and the case does apply, as the DIFC code also applies common law cases around the world. Secondly, just a moment, please. Secondly, although the primary applicant and the owner of the accounts were resident of the England in the second case, as mentioned, it was also about the law of the place where the object of the transaction is closely connected to, which also applies in a jurisdictional claim. And in the present case, the damages occurred as a result of the acts which were committed within the jurisdiction, and the law and the play and the object of the transaction, which is YAPL, is closely connected to DIFC, as one of the nodes on the service is based in DIFC, and hence the law of the DIFC also plays a role in deciding the jurisdiction. Furthermore, just a second. Furthermore, the parties also have a choice in choosing the governing law and jurisdiction, which is applicable by the Dubai contract law as well. Article 7.
Thanks, Payal. Is that
That would be
everything? Yeah, just as a point, I mean, I think your instructions are that the parties have agreed that if the DIFC court asserts jurisdiction, then DIFC law applies. So I think that's where it is. Great. I think that's now, James, we can turn to you. So the floor is yours.
Thank you, Your Honor. Good afternoon, Your Honors. My name, as you're aware, is James Braham, and I have the pleasure of continuing submissions for the appellant. My submissions, as is stated in my skeleton argument, and Your Honors are aware, surround the matter of relevant mistake. In brief, it is our submission that the court at first instance erred in concluding that for the purpose of a claim to avoid a contract for relevant mistake, it was sufficient to satisfy Article 37(1)(a) of the DIFC contract law to be shown that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was the result of an error. My submissions will be in two parts. It will take a look at subsection A of the relevant law and then at section 2 of the relevant law. May I invite Your Honors to turn to Article 37 of the DIFC contract law at page 30 of the appellant's bundle. The respondent relies on 37(1)(a), which reads, the other party made the same mistake or was also mistaken or caused the mistake, and what is relevant for the matter before Your Honors today, or knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. And the court is to determine, or is trying to determine, the test for the state of mind, that is what one knew or what one ought to have known. And it is our submission to your lordship, to your honor today, my apologies, memories of another place, that the correct test to be applied in the circumstances of deterministic algorithmic trading as obtains in this case, the test to be applied should be, when programming the algorithm, was the programmer doing so with actual or constructive knowledge of the fact that the relevant offer would only ever be accepted by a party operating under a mistake, and was the programmer acting to take advantage of such a mistake. And this was held in B2C2, a case of the Singaporean Court of Appeal, at paragraph 103 on page 65 of the appellant's bundle. And the case in Singapore, or from Singapore, is of note because the factual matrix is quite similar in that there is a claim for what we know to be relevant mistake. And further, it is in the circumstances of algorithmic trading in light of a glitch from the exchange. Now, the court below applied the test of a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade resulted in an error. And we submit that this is wrong. And that is because the test applied envisages, and I'm taking from paragraph 104 of the B2C2 judgment on page 66, the human trader completing the transaction, and there was none, and there could not be one in this case, as it was determined prior.
James, something's gone a bit skew with your microphone. Yeah, you've gone fuzzy.
Well, I'll attempt to.
Better.
I'll attempt to go from Yaro's computer. Is this better?
Clear. Yeah.
Okay, thank you.
I love this. I like how Yara can work with the computer and you can work. I mean, something makes sense here. That's teamwork.
Yes. Thank you. I don't know what was the last thing you heard. Well, if
you can repeat. Yeah, we lost you in the last 15 seconds. So I think the last. Go ahead.
Right. So I was saying that the reasonable trader test that was applied by the court below is the wrong test to be. Right.
Okay, now we lost both, I think.
Yara's computer just went. And is my mic still fuzzy?
It's better.
Yours works now, yeah.
Okay. Yes, okay. Well, we're back to the original place. My apologies. Well, so the test that should be applied, it is our submission, a test that should be applied is when programming the algorithm, was the programmer doing so with actual or constructive knowledge of the fact that the relevant actual or constructive knowledge of the fact that the relevant offer would only ever be accepted by a party operating under a mistake, and was the programmer acting to take advantage of such a mistake. And this was held at paragraph 103 of B2C2 on page 65 of the appellant's bundle. Now, the court below, the court of first instance, applied the test of a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was a result of an error. We submit that that is wrong. The test applied envisages a human trader completing the transaction, and there was none, and there could be none, as both parties to this claim, the appellant and the respondent, decided to invoke an algorithm to carry out trades on their behalf. There is no trader. And the test applied by the court below ignores the fact that the parties had committed to transacting with each other in a certain way, which entailed that they would not even know whether a contract would be formed, and if it were, on what terms that would be. And they chose in these circumstances not to bargain for a right to review, confirm, or invalidate any ensuing contract that may emerge out of the arrangements that they had committed to. And again, I've taken from D2C to a paragraph 104 on page 66 of the appellant's bundle. So it is our submission that the test of knowledge should be applied at the point of the creation of the algorithm that executed the trade to the person who created the trade, the program, that is the programmer, because they are the ones who executed the trade. In essence, it is just that the instructions for the trade were given in the past, because how determined algorithmic trading works is deterministic, my apologies, is that the program receives the instructions at when created and behaves in that way forever until the program is stopped. And so the point at which a trade was executed or concluded is not the correct point to find out the state of mind of the trader, but instead the correct point to figure out the state of mind of the trader would be when the algorithm, the program was created, because the trader is one who executes the trade. In this case, the algorithm. Therefore, it is the correct place to determine where the state of mind, what one knew or ought to have known, would be at the creation of the program. Further, Your Honors, neither the facts nor the law accommodate the court artificially interposing another last look at the prior to the algorithm concluding the contract, and for that matter, still left after. And I'm still at paragraph 104 of D2C2, where the majority judgment is interacting with Lord Manson's dissent, his proposition that there is a matter in equity to be dealt with, mistake in equity. And your brothers there continue to say that having committed to transacting this way, and in the absence of any basis upon which equity's intervention could be justified, up to the time the relevant offer was accepted and the contract formed, there is no principal basis for such an intervention premised on a review of reasonableness of the ensuing contract after it had been formed without any mistake to its terms. And we believe that dicta applies on these facts as well. We therefore submit, Your Honors, that the test to be applied is when programming the algorithm, was the programmer doing so with actual or constructive knowledge of the fact that the relevant offer would only ever be accepted by a party operating under a mistake, and was the programmer acting to take advantage of such a mistake. May it so please you, that is my first submission. I will now move to my, well, before I move to my second submission, I should say that usually when proffering a test to the court, it is prudent to humbly submit what we expect the result of that test to be. But the facts necessary to apply the test I have just offered to Your Honors today is not before the court. And in that vein, we ask that the matter be remitted to the court of first instance to determine the facts around the programmer's state of mind, what they knew and ought to have known at the time of creating the program. As that information is not before the court today, we won't seek to submit as to what the result of the test would be. And so that is indeed the conclusion of my first submission. So I'll move on to my second. So if Your Honors were so minded to disagree with the submission I just made, I'd invite Your Honors to consider the circumstances under which a contract cannot be avoided for mistake. And in that vein, I invite Your Honors to turn to Article 37, Section 2 of the DIFC contract law at page 30 of the appellant bundle. And it reads, a party may not avoid the contract, and this is in regard to relevant mistake, if A, it was grossly negligent in committing the mistake, or B, the mistake relates to a matter in regard to which the risk of mistake was assumed, or, having regard to the circumstances, should be borne by the mistaken party. And it is our submission that the respondent's claim relates to a mistake in regard to which the risk of mistake is assumed, and having regard to the circumstances should be borne by the mistaken party. The mistaken party, the respondent, had chose to engage in deterministic algorithmic trading. This is when users trade through programs uploaded to a platform that contained pre-programmed instructions about when to buy and sell. These algorithms, once activated, trade autonomously in accordance with their programming. They are deterministic in that they will always follow their programming rather than develop new responses to conditions. And as a result of this, trades are concluded without any
James, we're losing your voice. Just now we lost your voice. So maybe you want to try Yara?
Yara's just got kicked off as well. I think there's an issue with the Wi-Fi.
Okay, it's too noisy. We can't hear you. Okay, James, we just lost you the last I don't know, 6-7 seconds. So you could try again from.
Is it any better now?
Some, at least for me, I have a noise. I don't know about Peter.
No, I've got a noise too, James. So just tap the microphone or something. It just goes a bit fuzzy.
Do you have another PC open or? Okay. Try again, James.
Hi, has it improved? Okay,
Yes, better.
I have another PC. Okay, well, everyone just stay on. Stay on, wait.
Yeah, mute yours.
So we'll have all the PCs running in case I get, no, I think this, hi, Your Honor, am I okay now?
You should be okay. Just make sure that, you know, you turn off the mics for all the
Right,
other.
just keep, right, turn off your mics.
Not even on.
Oh, well, okay, okay, right. So the last few seconds, which is
Right.
has been somewhere away.
We heard
And so
we heard the intro of your second submission related to the risk and the Article 37(2) from DIFC. So you can just I think, and then you started the next explanation of that argument.
right, and so I had said last I recall is that I had described deterministic algorithmic trading, which simply put is trading in which a program is instructed on how to trade from at creation, and it carries out those instructions throughout its runtime. Once it's running, it's the same instructions that it was given at the beginning. These programs do not develop or change if changing circumstances that may arise. They don't involve human interaction. They just do as they're told for the duration of their existence. Now, we submit to Your Honor today that glitches are par for course with technology. And so the respondent would be aware, as I am aware, as Your Honor is aware from personal experience, that glitches happen. I've had a few glitches just today in submitting to you. And it as glitches are foreseeable, the respondent not taking steps for the algorithm that they created to adjust or to alert them to when there is an issue or a change in the environment is in effect, by way of action, the assumption of risk in this circumstance, the risk of a glitch. And it is on that basis that we say, that we submit to Your Honors today, that the risk should be assumed by the respondent and the contract not be avoided for a relevant mistake. And so it is our submission that one, the correct test was not applied at the court of first instance, thus the matter should be remitted and reheard with the correct test when the requisite facts are determined. And if Your Honors were so minded to disagree with that submission, it is our submission then that the contract should not be avoided for relevant mistake because the risk is assumed by the mistaken party. May it so please you, these are
Great. Excellent. Thank you very much. Should we move to Shakira then?
Yes.
The floor is yours.
Yes. Thank you, Your Honor. Your Honor, my name is Shakra Zainab, Junior Counsel for the respondent of this matter. I shall be dealing with ground 2 of this appeal, which states that the first instance did not err in concluding that the dispute trade between the respondents and the appellant was a result of an error. I shall, in support of this, make 2 submissions. First, a reasonable person should have known or ought to have known about the mistake. And second, one party is not allowed to take advantage of a mistake made by the other. If it pleases Your Honor, I will begin with my first submission.
Please proceed.
Article 37, Section 1, Part A of DIFC contract law on page number 8 states that the other party made the same mistake or was also mistaken or caused the mistake or knew or ought to have known of the mistake and was contrary to the reasonable commercial standard of fair dealing to leave the mistaken party in error. This article is based upon Article 3.5.1 of the Unit Right Principle of the International Commercial Contracts of the year 2004 on page number 98 to 99, which briefly explains the article, and on page number 100 of the Unit Right Principle, it mentions that the article indicates that the mistaken party may avoid the contract only if the other party satisfies one of the four conditions laid down. The conditions are as follows. First, both parties labored under the same mistake. Second, the error of the mistaken party is caused by the other party. Third, the other party knew or ought to have known of the error of the mistaken party and that it was contrary to commercial standards of fair dealing to leave the mistaken party in error. And lastly, the party other than the mistaken party had not reasonably acted in reliance on the contract up to the time of avoidance. Your Honor, the third out of the four conditions may satisfy the ground as the reasonable test must be taken to determine if the appellant have ought to know the mistake. I'll be referring, Your Honor, to the case Chui King Kong and others and DigilandMail.com Private Limited, reported in the second volume of the Law Report of the Commonwealth in 2005 on page 28. Your Honor, for further guidance, I would like to direct you to page number 7, paragraph 18, 19, 20 of the skeleton argument in the Respondent's Court bundle. For further judgment on the case, please guide yourself by clicking on the case name in the index on the court bundle on page number 1. For the benefit of Your Honor, may I reiterate the facts of the case?
You're referring to Chui Ken
Yes.
case? Okay.
Yes.
Okay.
In this case, the respondent Digiland Mail Private Limited was an online IT company that sold related softwares and hardware from Singapore. They were selling an HP laser printer and an employee accidentally made a mistake as to the price of the printer on their website. It was listed at the price of $66 when it was advertised on the official HP website for $3,854. This was not noticed by the company until over 4,000 printers were ordered. The appellant had ordered over 100 printers, each at this price. When the respondent discovered this mistake on their website, they sent an email to the appellant to say that they would not be fulfilling this order. The courts of Digiland Mail have stated regarding the reasonable test in paragraph 37 that if a party ought to have realized the mistake in the light of the surrounding circumstances, that will be classified as actual knowledge within the extended definition of willfully shutting one's eyes to the obvious. In the light of the circumstances, Mr. Payne did agree that there might be a mistake when he said even Ms. Razi had made a mistake. When mentioning Ms. Razi's mistake, the appellant willfully shut his eyes from the possibility of a mistake present in the dispute trade. Following this, the Court of Digiland Mail has also mentioned in paragraph 35 that phrase such as must have known and could not reasonably have supposed are evidential factors to find whether the non-mistaken party did in fact know of the error made by the mistaken party. Furthermore, Your Honor, I would like to draw your attention towards paragraph 38 of Digiland Mail case on page number 17 of the Respondent's Court bundle. The Court of Digiland Mail cites the High Court of the same case, stating that the reasonable man would harbor a real suspicion that the price may not be correct or that there may be some troubling underlying basis for such pricing. In our case, when the disputed trade was concluded at the price 250 times greater than the prevailing market price, the appellant ought to know that the trade was a mistake. In conclusion, under the reasonable man's test, the appellant ought to know the mistake when the error occurred. If Your Honor have no further questions, will I move on to the second submission?
Yes, I think so.
Okay, thank you. My second submission states that one party is not allowed to take advantage of a mistake by the other. I'll be referring Your Honor to the case of Hartock and Collins and Shields, reported in the third volume of All England Law Reports on page number 566. Your Honor, for further guidance, I would like to direct you to page number 8, paragraph 22 of the skeleton argument in the court bundle. For further judgment on this case, I would like to guide Your Honor by clicking on the case name in the index on page number 1 of the court bundle. For the benefit of Your Honor, may I briefly state the facts of the case?
Of Hartog, yes, please do, yeah.
Yes, thank you. The defendant contracted to sell 30,000 Argentine hareskins to the plaintiff, but by an alleged mistake, they offered the goods at certain prices per pound instead of at those prices per piece, which was approximately 1/3 or that of a pound. In verbal and written negotiation, which took place before the sale, reference had always been made to the price per piece and never to the price per pound. And expert evidence was given that the Argentine hareskin were generally sold at the prices per piece. Judge Singleton of the aforementioned case stated that the defendant knew about the mistake and took advantage of the claimant. In other words, realizing that there was a mistake, the plaintiff did what is described as snapping up the offer. This can be applied to our case as the appellant, Mr. Payne, ought to know that there is a mistake because of the absurd fluctuation of the price and took that advantage as he's getting $215,000 out of my client's bank account. If Your Honor has no further questions, I'll be moving on to my conclusion. Yes, thank you. On this ground, the previous ground given by my sorry.
Sorry, Shakira, before you just continue with the conclusion, Peter, how would you like to give time for the judge's comments?
I think this is going to go on a little bit beyond 12:30, isn't it? I mean, it really was sort of 11:30 to like 10 to 1 or something. I don't know. I've got very few comments to give. I've been putting them into the score sheets as we've been going along. So we could just hear Shakira and then we could do rebuttals quickly and then ask questions. How about that?
Okay. I have a couple of questions for both parties. Only one question, just for sake of time, one question here, one question there from my end. On the second item, second ground. Okay, please, Shakira, continue with conclusion.
Thank you. On this ground, as the previous ground given by my learned senior, it is accordingly submitted that Your Honor should dismiss the appeal and conclude that the court of first instance did not make an error in concluding that the DIFC court has jurisdiction over the claim by the respondent against the appellant under Article 5A1B of the Judicial Authority Law, and that the reasonable trader would have known that the dispute trade was a result from an error, which is in line with the previous decision reached. Unless I can further assist the court, my submissions are complete.
Thank you.
So should we do rebuttals and then questions for the purpose of time?
I think that's a great idea. Yeah.
Hi,
Mm-hmm.
Your Honor. Right, so you'd like me to go first with the rebuttal and then the questions? Very well. So, having listened to my learned friend for the respondent, we do have 2 points in response to the cases that my learned friend used. So, firstly, the first case of Digimail, we submit to Your Honor that one, that is a matter of, this is a case dealing with algorithm against algorithm, while that is a case of human versus human. Secondly, we submit that the nature of the case is that it was a online. Well, when I say human versus human, there was a human interacting, and there was no human interacting in the case before Your Honors today. Secondly, the nature of the sale is that the party was purchasing a product that was for a set price, and it is not a variable price as is on an exchange. It's not trading, and so it is what one ought to have known is ascertainable, as we all would know what a printer is sold for. And so it would be unforeseeable that the printer could be sold for so little money, and that is the basis upon which the matter was upheld for mistake. So secondly, the second case that my learned friend used, and I apologize for not remembering having the names written down, but it again was a matter of not only shopping but in-person bargaining and negotiation. We submit that this is a trading platform where all parties are seeking the best possible price at which to sell and the best possible price at which to buy, which is on the facts, the instructions given to both the instructions given to both parties, the claimant and the respondents, algorithms. And so it is not, so that the first point is that there was no negotiation between the parties. The algorithms were acting in line with their instructions. So again, we submit that the appropriate test is to ask the state of mind of the programmer at the time of creating the program, because there was no in-person negotiation. There is no person to ask what their state of mind was. And we ask your honors also to consider the nature of trading, that everybody is trying to get the best possible deal. Now, you can only buy for what somebody is selling for. So if you're in the market to buy, you're in the market to buy. And per the instructions given to your algorithm, you're in the market to buy at whatever price is available in the market. And so, you know, I don't know if this is going outside the scope of our submissions, but parties are free to put, instructions in the price at which it's just a question of whether anybody.
James, just now the noise started. So.
Oh dear. Okay.
Now it's okay. Now it's working. Keep going.
Oh, now it's fine.
Yeah.
Right. So I was saying that the nature of trading on trading platforms is such that one puts the price at which, one hopes to sell it at. And if somebody is available, if someone out there wants to buy it at that price, that is indeed their prerogative, which is completely different from two people haggling in a market or online, purchasing on a website where there is clearly an error with a printer being sold for an outrageously low price that wouldn't make commercial sense. Finally, my learned friend referred to in an attempt to attribute that to the claimant, not the claimant, to the appellant, in an attempt to attribute to the appellant that they intended to rely on the mistake. My learned friend read from the agreed bundle a brief quote that even if Miss Razi had made a mistake, I would like to finish that quote. So the appellant said, Mr. Payne, even if Miss Razi had made a mistake, when he programmed data, he did not make the same mistake as Miss Razi or cause her mistake, and he did not know or could not have known about Miss Razi's mistake. Note the claimant's response to the specific part of the knowledge test in question. And so there could be no grounds to avoid the disputed trade. If my learned friend for the respondent is accepting that statement, we agree with her in full that there could be no grounds to avoid a disputed trade. Those are my submissions in reply to my learned friend for the respondent. Made so.
Great, and Nasser, you've got questions. Would you like to go ahead with them?
Thank you. I think one of the questions to Shakira was already highlighted by James, so I'm gonna get into that. If you want, I can just focus on Shakira, and after I finish with Shakira, I'll go back to James, since he already asked the same question. That your argument about the case that you brought into your let me just refer to it exactly. I think it was the DigiLandMall.com is exactly, this is related to a set price purchase versus in trading exchange. This is a dynamic, you're really seeking the best price, which is a trading that is not a set price where you have a one default number that you expect and then there was a mistake on that. This is a keep changing environment. So how would you argue back into the applicability of that case in our scenario here with Clivity? Shakira, I'm just following up on James' question because it was one of the questions that I have. You're talking here about dynamic environment versus in terms of pricing versus a set price, and there is a wrong number that was inserted. Could you just explain that, Shakira?
Yes, Your Honor. In terms of pricing, right? The market, in our case, the market price have risen absurdly compared to what was lost. Yes, it was dynamic. Yes, the market price is dynamic, but rising up to 250 times more than what it was, it is absurd. So that's why my client wants um, uh, hmm. So that's why my client wants a
Yes, Shakira, say it in simple English.
yeah, I'm just like, I'm sorry.
So we were talking about that this is a dynamic price.
Yes, it is it is a dynamic.
It's been multiplied by 250 times. That's why your client
Yes.
what?
That's why my client wants the basically wants the money back, because compared to the market price that was before and right now, which is like 250 times greater, and it was caused because of an error that the disputed trade happened. And not only that, it was only two of them that were in the Clevity application. Not everyone else were dismissed because they didn't have a certain amount of money, a certain amount of value in their account. So we wouldn't classify this as fair and reasonable.
Okay. Then if you allow me, Your Honor, to go back to James in that case. Yes, thank you, Your Honor. Again, Shakira, just before I conclude in this, in crypto assets, to see the multiplication of 250 times in a short time, it's common environment in crypto. So we've seen even higher than this in a shorter time. So this is a different nature of assets where you see the returns can multiply to 100x, 200x in a very short time. Now I go back to.
Can I ask a question, if I may?
To me or to James?
No, to you.
Okay, go ahead.
Is it because of an error that happened more than like 250 times?
We're talking here about two different matters. One was that you saying that DigiMail apply. I'm really looking at your argument and whether it's applicable or not. You're saying that the case of DigiMail was a set price. There was a mistake on that price comparing to the other price, $66, for example, comparing to 3,000 something. So it's not a dynamic environment. It's a set price and so on. In your case, it's a dynamic trading, so the prices can go. But then you said, yeah, but it's a mistake because the number multiplied by 250 times in a short time. And I was saying that in crypto, it's expected sometimes to see this raise in a very short time. So I'm just replying to specific arguments, not talking about the error part of the subject. That's another argument that I'm not saying that it didn't occur in terms of an error. Now back to James, since I'm just building into your error question here. In your second, okay, so you had two arguments here that you made, James, if you allow me. I'm going to start with the second one, which is the risk. And part of it, you're saying that, the alpha program. James, I'm sorry if I'm, is it James? I heard something.
No, it's James. No, it's James.
Okay.
I'm not sure if my mic is fine. Is it?
Yeah,
okay.
Fine. Yeah. So in your second argument related to the risk, basically, and you're claiming that the alpha programmer, in that case, Rani's client in here, they did not take risk into account, enough risk into account. So a risk management problem when programming that. Did I understand that correctly? And
yes, those are my submissions.
thank you. Then claiming that it's minor glitches like that would happen. But the thing is that I don't know what's your reply when we say that this is relatively new environment in here. This is not just a glitch because you are programming something for the best market price. You're trying to catch the best market price, and if the $2,500 per YAPL was the market price, why would that be a problem with alpha program? Maybe it would not be a problem. Maybe it would be a good catch because they can sell it for 3,500 later on per YAPL. So is it really a minor risk management that could have been avoided easily, knowing that it's really catching the best price? Taken into account an external error happened that show to the normal algorithm that this is a good catch price and he can probably resell with a better price. So do you see it as a minor programming issue, or it's something that possible? It's not really negligible error. Yes, so it's not an act of negligence, you know, it's really a tough problem to fix in a programming, knowing that you are not really, you're really trying to catch the best price, and the price was shown to be the best one.
It is.
And an external error also was in place. So just how do you see this act of risk management that could have done better?
On the matter of risk management, it's our submission that the program is fairly simplistic. I mean, the best available, what it is in essence, what the program has been set up to do is what is known. I don't know if you can still hear me. I hope you can.
I can hear you well.
Oh dear. Okay, very well. What is known in stock markets as market price. What the respondent has done is created a program to say buy the cryptocurrency at whatever price is available. There now, as the respondent is aware that this would be algorithmic and deterministic, we think that, or we submit that the risk management steps could be taken, such as alerting a human to step in or to check if the price has gone up a certain amount. But as Your Honor rightfully identified, in the crypto space, it is normal for large increases in percentages across a day or an hour or whatever the case may be. And so it may very well be that the respondent wanted to take advantage of such circumstances themselves, and in that case would have assumed the risk. Now we accept that the error was external. It was a matter not of the claimant, not of the appellant, and certainly not of the respondent, but an issue on the exchange. But exchanges have had errors before, and not necessarily crypto exchanges, but stock exchanges, which have been around a little longer than cryptocurrency. And so a prudent investor creating a program would seek to take steps for risk management for the potential of risk of a glitch if they have determined that they do not want to be a part of the trading process. Some fail-safe, some backstop must be put in to take care of any issue that may arise, as issues do arise. And so we believe that then the risk should be assumed because of that failure.
Thank you, James. I have no further question, Your Honor, and thank you for your time.
Brilliant, everybody. No points from me, no questions from me. I think that part 2 question, that second ground, is really hard. Knew or ought to have known under 37(1)(a). It's really a picky question, and Lord Mance's judgment is difficult to get to grips with. The difference between subjective and objective knowledge. And the line of fairness, in my view, it all comes down to fairness. Is it fair that Mr. Payne is never going to say that he anticipated the circumstances which led to the disputed trade. But we would see it as a windfall, I think. And that, to my mind, is what happened in the Singapore Court of Appeal, where in fact Lord Mance's judgment is in the minority, and the majority of the Court of Appeal upheld the first instance judge, who applied that very strict question of what was in the programmer's mind at the time of programming the software, not what was in the program, what would the programmer ought to know when he or she realized of the error that had taken place. Shall I could give 30 seconds of feedback? I spoke, everybody's very clear and concise. It was good to see signposting, people saying what they were going to say. I've got 2 arguments, I've got 3 arguments. My first argument is this. It really breaks things down. Well done for taking us to the appropriate sections of the authorities and offering summaries, which we took. You know, we didn't have to. We could have said, "Oh no, we've heard these authorities before. Don't worry. You know, take us to the. We don't need to know the facts. Just take us to the material sections." But well done for offering us those. And finally, well done for taking our questions. You know, there is in appellate work a lot of to and fro. In fact, many of the best appeals aren't really that you don't really give the advocate time to sit there and read out a speech. You just get straight into questions about what do you think about this, what about that, hypotheticals and things like that. So that's all I want to say.
I just want to echo what Peter just mentioned. This is really 2 brilliant teams, honestly. Well done by all means. In a very short time, good preparation, good submission, written and oral, and your taking of the questions was really, really amazing. I was tough in asking some of the questions, but you guys were brilliant, honestly. You should be proud. So well done, honestly.
Brilliant. Well, if there's anything else, we now
Thank
send
you,
our filled-in sheets back to Delvin, sorry, and she will then contact, I suppose, everybody to let them know who's going through to the next round.
Yeah,
thanks.
I would just want to add one simple comment in the future. One simple comment, just to think about, would be that knowing that you're dealing with a technical problem, you tackled it well from the legal aspect. It's not wrong to use a high-level technical explanation in the beginning of your argument, like a higher level explaining to the judge the high-level concept of how nodes or blockchain work and why do you see there's, for example, a jurisdiction or you don't see a jurisdiction, because that's a very important aspect related to the first ground of this. So, of course, you're not there to explain how things, you know, in programming works and all the details, but highlighting that in the beginning will give a much stronger argument later on when you tackle it from the legal perspective. That's my thing, and I would ask Yara to go a little bit and read more about nodes and blockchain. You might have a stronger even argument when you make this. But honestly, brilliant submission and oral defense. Really amazing. Thank you, all of you.
Brilliant. Thanks, everyone. Bye.